Banking and finance law is notoriously complex and highly technical. Rules and regulations are evolving fast following the recent global economic crisis. Failure to comply can carry hefty penalties. Whether you're a borrower or a lender, issuer or fintech startup, having an excellent banking and finance lawyer on board is essential. Hello, everyone, and welcome to yet another episode of An Hour with Lawsikho. I'm Aditya, and today we are in conversation with one such phenomenal banking and finance lawyer, Dhwani Shah, an associate with the banking and finance team of Khaitan and Company. She regularly advises a wide array of clients ranging from public sector banks, private banks, NBFCs, multilateral financial institutions, corporate houses, ARCs, and distressed funds on general financing transaction and insolvency and restructuring matters. Today, she'll be talking about insolvency laws and its scope as a lawyer in India. Dhwani ma'am, we are absolutely delighted to have you on an hour with Law Seco. Thank you so much for agreeing to do this.
Thank you so much, Aditya, for the introduction, and it's been my pleasure and privilege to be doing this.
All right, ma'am, let's quickly start with the session. My very first question to you is that can you please tell us a little about yourself? How were you at the college? How was your college life? And how did you go ahead to associate yourself with Khaitan at this point of time?
Okay, so I'm actually from Government Law College, Bombay, and I started out with my articleship at Vadya Gandhi, which is one of India's, I would say, oldest solicitor firms. And I was at Vadya Gandhi for 3 years, and I did rotations of corporate, real estate, and litigation for a year each. After which I went on to my study leave, and I took some break, and then thereafter I joined Khaitan as a lateral hire.
Thank you for the introduction of yourself. How did you? Okay, what is your job role as an associate in a BNFT? What kind of matters and laws you deal with every day?
Right. So banking and finance, especially at Khaitan, is a very wide spectrum of work. So when I started out, which was back then in 2016, we were doing a lot more traditional conventional work, which included real estate financing, which is for law students out there, like to put it simply, like for example, when a building has to be constructed in a metro city like Bombay, and the land and the construction costs would total, to a couple of thousand crores. There's always a bank or an NBFC which will fund this, either the project basically. And that is essentially what you call real estate financing. And this is picking up across the country, whether it's tier 1 cities or tier 2 cities. Secondly, we also do a lot of project financing work, which is essentially your infrastructure projects. So, for example, every time a bridge has to be constructed, naturally, you need financing for that, and it's not always possible to fund it through equity, and therefore, companies do rely very heavily on debt or debt instruments. We also do, some amount of debt capital, market work, which is essentially, issue of debentures. Debentures, again, as an instrument, it's a loan instrument. It can be either listed or unlisted. However, as we all know now, the Insolvency and Bankruptcy Code has come in, and that's largely overthrown, the older regime. And since about a year and a half, that field has picked up, and I have largely been now focusing on insolvency matters, which have come in. And of course, again, as we all know, Khaitan is doing all the, sort of prime work with the top 12 RBI accounts and even, the other mid-size accounts, so to speak. And of course, work again on that front has really picked up. So definitely, and it's a very interesting time as well because, insolvency is not just debt, but it's a combination of debt plus equity plus some amount of litigation as well. It's definitely a good learning experience because everybody's starting out on a fresh page and everyone's learning on the job, if I could say that. So yeah.
All right. Ma'am, the next question that I have for you is your advice to young students who are watching to wish to enter BNF team of Khaitan. What does banking and finance practice team as a team encompasses? And I also have a question right now from Arvid Antithian, whose question is that how was the interview at Khaitan and how did you crack the interview?
Okay, so I'll answer that in two parts. One, for anybody who's looking to specialize in banking finance, I would suggest like while you're still in law school, you should at least do one internship in a good banking and finance team, whether it's in Bombay or in Delhi. In a team that sort of focuses on a spectrum of work because like now as of today, like I said, we have everything ranging from insolvency to real estate financing to advisory work as well. So you have to be somebody who knows what it takes and the kind of volume that you have to deal with once you join the team. And it's definitely more rigorous than a lot of times than corporate teams as well because debt predominantly is volume work as well. So yes, an internship would definitely be helpful. It's of course helpful to read as many blogs as you can because now the entire debt and restructuring regime is being overhauled. Like for those of you in the know, there were circulars which were essentially your strategic debt restructuring schemes and your corporate debt restructuring schemes, which were outside of the court process and outside of the IBC process. And even those have now been recalled by the RBI because we're moving towards a more court supervised process, which is definitely a lot more structured and disciplined, the way we look at it, as is time bound, which is the most essential, and it's also problematic in a way. But yeah, I mean that entire principle of restructuring has now changed, over the past 1.5 years. Two, on how did I crack Khaitan and Company? I was not a college hire because, like I said, I did my articleship at Vadya Gandhi and my work experience, and like it basically stems from my experience at 3 years at Vadya. But of course, I applied to Khaitan and Company, and I sat 2 rounds of interviews. While you sit your interview, as anybody would tell you, whatever it is that you put on your resume, whether it's 2 things or 10 things, you must be very confident about it. Don't put 100 things and then sort of look blank during your interview. I think that's one thumb rule. So if you literally, if you even if you've done 2 things, it can just be 2 internships or like 2 articles or 2 modes or whatever it is. You should know that really well and really thoroughly to sort of answer all questions that come your way. And of course, if you've interned at the law firm or during your law school years, that helps. And while you're interning, you must take it really seriously because at least now the big 5 or 6 firms, at least here at Khaitan, we have a very structured process where we evaluate interns very seriously. So if you are good and if you've put in good work during your internship month here, it's always recognized.
All right. Thank you so much for that answer. I hope that that is going to help a lot of students around us. So you just told us that there have been a lot of recent amendments and there has been a new act that has been brought into the picture, which has made everything very structured. What are some of the basic things about insolvency and bankruptcy code that people should know about? Could you please provide us a gist of the code's framework?
Okay. So, again, to start out with, so let me start out with, a pre-insolvency backdrop of, where India was
That would be
in
beautiful.
the, yeah. So before the insolvency code came in, we had the SICA regime, and we obviously had the DRTs, that were overburdened with all the cases before it. The SICA regime unfortunately could not really, do what it was supposed to do, which was, rid the companies of bad debts. And a lot of cases just, ended up in litigation, and they would, without any resolution in sight. What happens with these companies once they're sort of recognized as a sick company? There's a lot of net value and asset erosion which takes place, which is very difficult to recover because I mean, to put it in a very layman way, let's say you have put 10 rupees of your money into a company and you sort of realize that, okay, this is now, going to be liquidated or it's not a company that is, profitable anymore. That sentiment itself sort of, leads to a vicious cycle where not just your shareholders, but also, let's say, you may have third party contractors who supply, raw material, or you have your other, creditors. They could be like banks or financial institutions. All of that gets triggered over a period of time, and the net asset, erosion was so deep that it was getting very difficult for companies to recover from that. Because once banks recognize that a company is unhealthy and is unable to pay its debts on time, they will, there's a concept called non-performing asset classification, which is very important. I mean, for everybody who's looking at, ever doing banking. So the NPA concept is basically that in the event that you are unable to pay your debts for a certain period of time, then the bank will recognize your account as non-performing. Once it is recognized as non-performing, there are a lot of issues which get triggered along with it, including not being allowed to borrow more funds through your public sector banks, which is also fair. So for companies like that, and especially when they were operating at that level, it was getting very difficult for them to come back. To or sort of it was very difficult for these companies to have a fair chance at resolution. So that is why the insolvency code came in. One, it was time bound, and also it offered a very it offered largely a transparent process for third party bidders to come in and say that, look, okay, this company has a debt of, let's say, 1,000 crores. We are willing to put in 800 crores. Let the banks take a haircut of 200 crores. Just to, I mean, giving you a very, layman example of how this works. And also it's a court supervised process. So everything that happens, it happens on record and it is placed before the NCLT. So this was basically what the objective of the code is, that, to achieve resolution, and to achieve this resolution in a time bound manner so that, the assets don't go further downhill. On the framework of the code, uh, there are certain pillars of the code. Okay, one is your NCLT, which is the authority, which is the court. When we talk about a court supervised process, that's the court that we're talking about, and NCLT has its benches all across the country. So there's a bench in Bombay, Delhi, Hyderabad, Calcutta, Guwahati, and so on and so forth. You have the resolution professional. So the resolution professional is basically the most important, pillar of this entire framework, so to speak. The resolution professional is one person who takes over the entire management and affairs of the company. Now, a question that one may ask is that when does a resolution, how does it get triggered? To put it very simply, let us say,
I'm really sorry to interrupt
yeah.
you in between, but there was a little voice breakage. Could you please come again with the last sentence?
Okay. So, just going back on how does one trigger this process and what is this process? Um, at any point of time, when you have a creditor, whether it's a bank, that's a financial creditor, or let's say it's an operational creditor, let's say some third party contractor who was supplying raw material, or somebody who was, conducting operations for you. If you have not been able to pay debt worth 1 lakh rupees or more, you can go, that person can go and trigger something called as an insolvency resolution process against the company. So basically, you will file an application before the jurisdictional NCLT saying that, look, my money has not been paid. This is the evidence of that, and request you to initiate CIRP against the corporate debtor. If it's a financial creditor, there's no demand notice, etc. also that you have to give. If it's an operational creditor, you need to give the company some demand notice to say that, look, please pay up my money, otherwise I'm going to go to the court to institute proceedings. So again, this is going in a very layman, sphere, and not really talking very technically, because I understand the audience is going to be law students per se. Thereafter, the NCLT will take on record all the pleadings that have been filed by such creditor, and if there is enough evidence, then they admit the application, and the company goes into something called as the corporate insolvency resolution process, which is commonly known as the CIRP. During the CIRP, there's a moratorium which is instituted, During the moratorium, you cannot do anything against the company. So all litigations, all actions that you would have otherwise taken against the company, all of that comes to a standstill. And then thereafter, the resolution professional is appointed who works towards resolving all issues of the company. So there may be compliance issues, there may be issues with respect to bad debts, there may be issues where, let's say the company needs interim financing of, let's say, 50 crores. So the resolution professional will approach, parties to raise that, minimal financing that the company needs to keep running, etc. And then thereafter, the resolution professional makes a public announcement asking all third-party bidders to put their bids. To say that, okay, fine, this is the company, this is the debt size of the company, and how much is a third party willing to pay, and then so on and so forth. So that is basically allowed for a period of 180 days, which can be further extended by a period of 90 days. And then if in this period of 270 days, if the company cannot achieve resolution, then it goes into liquidation. So this is the simplistic framework that we have as of today.
All right, you beautifully explained the framework. Could you please tell us as to in this entire cycle, right from the identification of the company to the bidding process, where does a lawyer's role come into play?
So, okay, that's a good question. A lawyer's role, so there are three main stakeholders that are going to require a lawyer on the side. One is the committee of creditors. Let me explain the committee of creditors angle to you shortly. Two is the resolution professional that I just explained. And three is the third party bidder. That is basically the person who's going to bid for this company that has gone bad. Committee of creditors, coming back to it. What is a committee of creditors? There will be, let's say, 5 banks or 10 banks, or in some cases, 50 banks also, to whom the company has not been able to pay, the principal or the interest amount. Such banks will file their claims before this resolution professional, and thereafter the resolution professional will admit those claims and he will form something called a committee of creditors. So basically, all the important decisions which have to be taken during this 270 period by the resolution professional, whether it's let's say amending the articles of association of the company, or raising further finance, or amending certain documents, basically the existing contracts, or negotiating with any third party. All of these decisions are taken by the committee of creditor. The most important decision the committee of creditors takes is the approval of the resolution plan, which has been submitted by the third party bidder. So it's only once the committee of creditors approve this resolution plan can it then be placed before NCLT for its final approval. If the committee of creditors rejects such plan, because let's say if the debt size is 100 rupees and the bidder is saying, okay, I'm willing to pay you only 40 rupees, and the lenders are not willing to take a haircut of 60 rupees, they have a right to reject the plan and send the company to liquidation. So, yeah.
I have a question right now. I'm going to take this question from Himanshu Meni, who wants to know whether the amount of default under the code should be increased or not. What's your opinion on it?
Given the framework and how serious the implications are if it is admitted into CRP, yes, it should be increased. But having said that, I don't really think there's been a lot of adjudication on that, or usually nobody bothers for a small amount. And also NCLT would be very wary of taking into account, like, let's say, a debt claim of 1 lakh rupees, and before you do that, I think the corporate debtor would happily come and clear your debt instead of going through this entire process. So, yeah.
All right. I'm going to go back to the basics right now, yet again, and I'm going to take a question from Kunal Chandrani, who wants to know that apart from the IBC, what are the other laws that are required to be known for a person who wishes to be a part of the insolvency field? I'll put it as banking and finance team of a law firm.
I mean, is the question to say that apart from IBC, what else is it that you can practice within the insolvency and restructuring regime as of today in India? No, you have to, I mean, this IBC is the main legislation. It's like saying I want to be a corporate lawyer and not do Companies Act and SEBI laws. But
Yeah, in addition to that, he also wants to know that what all he can study for his knowledge purposes if he wants to get into the team.
You can, of course, start out with the insolvency code. There are a lot of, blogs online which talk about every nuance of the code. So once you had a reading, in fact, Khaitan and Company does Arrows, which are available on the Khaitan and Company website. They're also available on mondac.com. And not just Khaitan, a lot of other law firms also who publish articles from time to time. So yes, once you had a reading of the code, you can always pick up these articles and read them. They're very informative and would be useful in the longer run should you want to intern or practice as an associate within this.
All right. Kunal, also for your information, Creditors Lawsikho also has a course running on insolvency. I'll put the link in the description below. You can go through that course and learn a lot about insolvency laws in general. I'll get back to you, Dhwani ma'am, and I will ask you the next question, which is in your opinion, whether the Insolvency and Bankruptcy Code 2016 has provided a timely resolution of the corporate insolvency, and how has the implementation of the code been so far?
So far as timely resolution is concerned, look, I mean, 270 days is given the whole Indian, ways of being, and the fact that courts also take a lot of time, for like if it does go into the litigation leg, it's not sufficient, is what we found in a lot of cases. Having said that, it's of course, been a measure of making sure that at least the process is done in a time-bound manner. All stakeholders are aware that there is a clock which is running out and that they need to, act accordingly. Um, a lot of cases are not getting resolved in a period of 270 days and they are in limbo. But having said that, it is a lot better and a lot more time efficient than our previous regime.
Okay. So my next question to you is that what are the issues and challenges does an insolvency professional faces after the initiation of the moratorium period under the Insolvency and Bankruptcy Code 2016?
So I think, being a resolution professional in charge of a company, especially where the debt size is big, is a very stressful role to play. It's because one, as of today in India, we don't really have a limitation of liability concept, and neither has professional insurance evolved to that level. So I would think that resolution professionals would always have to, deal with, that issue that tomorrow anybody, whether it's an operational creditor whose claim you have not accepted, or whether it is, a bank whose opinion you not taken on record, or whether it's the corporate debtor himself who, the current management of the corporate debtor itself who's of the opinion that the resolution professional is not running the affairs of the company, efficiently. All of these, are stakeholders who can come and challenge the resolution professional while he's carrying out his duties. And that is why, resolution professionals have to be very aware of, the entire process and of their responsibilities under the process. Um, Also, from an employees and workmen perspective, we've seen cases where, again, RPs have been very burdened because, workmen and employees don't understand the nuances of law. You don't expect them to. So a lot of cases, let's say where employee wages or employee and workmen dues and wages have not been paid, they've come up to the RP saying, but our money is with you, so please pay the money. So you also have to deal with those day-to-day affairs of the company, which are, other than the paperwork, etc. Even those have its own, challenges, is what we've gathered, from our clients who are resolution professionals. And other than that, of course, I mean, as any professional, you have to carry out your duties as per law, which is basically to go back to the committee of creditors for any decision you take, or to work towards resolution of the company. So basically run the entire process efficiently and in a time bound manner. So whether that's a public announcement, or whether that's collating the claims and accepting claims of people who have claims against the company, or whether that is generally also running the company on a day-to-day basis. So filings, or like giving out your instructions to people on the floor. So yeah.
Thank you for that answer. My next question to you is that what happens to the ongoing litigation against the corporate debtor
Sorry, your
once?
voice is not audible.
Can you hear me now?
Yeah.
My question is that what happens to the ongoing litigation against the corporate debtor once the application is submitted?
Right. So, again, coming back to the whole concept of moratorium, what is moratorium? Moratorium, which is specific, it's one of the most important sections actually of the IBC, which is section 14. It says that once your, CRP has been admitted by the NCLT, there is no litigation that can be continued against the company. You cannot terminate essential contracts against the company, which means, let's say, your rent contracts, etc. And you cannot terminate your essential, services. So, which means your water services, electricity services, etc. So, sorry, just one second. So in that case, a moratorium protection is very essential to the entire concept of achieving resolution, because this is not a regime where where the first objective is to liquidate the company. The first objective is to give that company an opportunity, because I mean, whatever said and done, if there is a company which is operational, which has 100 or 1,000 employees, which are up about and running and depending on the company for their livelihood, it must not be sent to the gallows for liquidation. So this 270-day period is a pre-liquidation or a you could call it like an opportunity for the company and for its revival. And in that sense, I mean, that what do you call, the insulation against litigation is very important, and which is what the code has provided. So for example, if you have like litigations which are ongoing in respect to the company, all the resolution professional has to do is bring to the notice of the respective forum. So whether it's the High Court, or it may even be the Supreme Court, that insolvency proceedings have now been initiated against the company, and therefore has gone into moratorium. And only once this period lapses can you now hear upon or adjudicate upon these cases. And that is very important in a lot of ways, because that will also protect you from any income tax proceedings, from any stamp duty proceedings, from any real estate proceedings, all of that, and it will bring the company's focus onto insolvency resolution.
Thank you so much. I'm taking a question from Himanshu Mene right now because you've been talking about the protection of the companies. India does not have a market for providing interim finance for running these insolvent companies for a longer period.
So your
What would
voice
you,
is not audible.
can you hear me now?
Yeah, slightly
All
better.
right.
Can you maybe adjust your mic?
Yeah, my mic is actually attached to the camera, so if I adjust the mic,
Okay.
the camera gets adjusted. Anyway, I'll try my best to speak more loudly. The question is from Himanshu Mene. He wants to know that India does not have a market for providing interim finance for running these insolvent companies for a longer period. What would you suggest to what would you suggest to increase the supply of interim finance?
Okay, that is a very good question. As the code, if you've had a chance to, read the code, thoroughly, if the company does go into liquidation, then any person who has provided interim finance is paid first. So such person is paid before any, employee or workman is paid, before any, financial creditor, or any operational creditor, or any shareholder, or other person to whom the corporate debtor owes any debts or dues. Interim finance is now forming part of the entire corporate insolvency resolution process cost, which is the first in line to be paid. So, for example, if a company has raised 50 crores during this period of, let's say 270 days, then any third party bidder who comes in, before he proposes payment to any other person, he must make sure that he has provided for this interim finance. Having said that, of course, the sentiment for providing interim finance to a company which may go into liquidation in in the next couple of months, that is obviously a commercial risk that one has to analyze. And but we've seen cases where interim finance has been provided, though not of a large sum, because the whole concept of interim finance is essentially to make sure that the affairs of the company are running. It won't really be to, let's say, acquire another asset or acquire another business or undertaking. So it's of a small amount.
All right. I am going to proceed with another question from Himanshu Mele. And his question is that is it realistic for big companies like the 12 companies referred by RBI to resolve the insolvency in 270 days?
So, like I said, it is a limited, time period, and 270 days is has not been entirely sufficient, given the speed at which our courts function. Um but I mean, having said that, again, it's a time bound process, and the entire it'll evolve over a period of time. And it's not really like per se. I personally, I don't think extending the time period on paper at least, or statutory at least, will help, because tomorrow you will extend it, you will have it extended to 360 days or to 1.5 years. It's not that that may help, because I mean, ultimately a lot of time does get wasted when there is time available. Like, for example, if you extend it to 1 year, then there'll always be a lapse of 3 months in the middle, because the bidders are also of the opinion, okay, there is some time remaining. The resolution professional is also of the opinion, okay, there is some time remaining. So statutorily, 270 days reasonably works. And of course, courts may over a period of time allow some amount of leeway on equitable grounds. Like, for example, if it's an ideal case for resolution but has not been achieved in 270 days, but has been achieved in 300 days, then NCLT would not reject that plan only on that ground.
All right. Himanshu, I hope that answers your question. My next question to you, Dhwani ma'am, is whether the creditor-centric approach under the approach is beneficial for insolvency resolution.
It is definitely, beneficial, because in the previous regime, again, we've seen cases of the funds being siphoned off. So the idea of actually taking out the current management out of the company and placing all the powers essentially of the board of directors, in the hands of a resolution professional who runs this in a very, very professional manner, has been, a big plus point. Also, from a trust perspective, that works for all the stakeholders. So far as creditors in possession, I would not say creditors are in possession. Of course, they have all the important decisions to make. But like, having said that, it's still the resolution professional who's going to run the affairs of the company as is. It's not that he can turn around and overthrow the way the company was run. It's still run with the same staff and the same KMPs.
Uh, All right. Okay, so in this context itself, I have to take another question, and this question is also coming from Himanshu Mene. And his question is that shouldn't the operational creditors be made a part of the committee of creditors?
So when you look at operational creditors, financial creditors, even under the liquidation proceeds, basically when the company goes into liquidation, they are the first ones to be paid. So they are the higher, what do you call it? They have a higher claim, or they have a priority claim, under the code. So in a situation where a financial creditor, like where financial creditors exist in the company, it would be difficult to argue that operational creditors should also be given a place in the committee of creditors. Um, if you read the provisions of the code where there is no existing financial creditor, the code provides that the top 18 operational creditors would form the committee of creditors. So the code has recognized, the rights of operational creditors, but these rights are not superior or over and above the rights of financial creditors.
All right. Thank you so much for answering that question, Himanshu. I hope that answers your question. I'm going to take a question from Kunal Chandriani right now. His question is, can you please throw some light on the National Insolvency Exam? Is a law graduate eligible to appear or prior experience along is also criteria? Can you also practice without having to pass the exam?
Right. So there are two insolvency examinations available as of today. One is a limited insolvency examination, and the other one is a national insolvency examination. The limited insolvency examination is, of course, available only for individuals with experience. So whether it's CAs or lawyers or CS or such people who've had experience in management or finance, and the threshold varies, but I would say on an average 8 to 10 years. You can go on to the ibbi.gov website and check out the basic threshold. So far as the national insolvency examination is concerned, I'm not aware if that examination has opened up. It could have, but at least until like 6 weeks back, that was not available, because as of today, the country is focusing on making sure that at least all insolvency professionals, or all people who are sort of entitled to take up this job, are more at a senior level, and they would not want law graduates to you know like for example somebody like me who's relatively junior, to be taking up the role which is as serious as that of an insolvency professional, because it's a lot of stress and it's a lot of responsibility. So largely we see, like, let's say partners of, like, the big four accounting firms, that's Ernst and Young, KPMG, etc., taking up these roles, or they're partners of BDO. So it's not anybody or everybody who can take up this kind of a responsibility.
All right, I hope Kunal that answers your question. My next question to you is that NCLT is also a pretty recent adjudication authority that has come into picture after the enactment of the Companies Act. How is NCLT performing as an adjudicating authority in insolvency cases so far?
So NCLT, in fact, has been faced with a lot of volume since last year. I mean, last January or February, so to speak. And while, of course, they've NCLT has not been able to abide by the 14-day time period which is prescribed under the code, for adjudicating on these cases. NCLT has been very proactive on insolvency matters. So if you look at the NCLT website and you see the volume of orders, which NCLTs across the country so far have adjudicated, it's been a lot of matters that they've heard, and they've heard and admitted or rejected, on various grounds. So yes, volume wise, NCLTs have been burdened, and they've been doing a phenomenal job so far as turnaround of these cases are concerned. Because I mean, at the end of the day, NCLTs are also like grappling with the nuances of this law, which is in its nascent stages. So.
All right. What are the measures that, and this is a question again by Himanshu Mene. The question is that what are the measures that are being taken to prevent frivolous petitions under the Insolvency Code?
So far as frivolous petitions are concerned, NCLT and even the code is very clear that you must, provide evidence of any claim. So in the event that, you have filed a petition which is frivolous and it's not really substantiated by documents. So for example, if it's a loan claim, you need to have documents such as your loan agreement, your receipts, you know, reflecting that that money has been discharged, or any security documents, etc. Now, for example, if a person frivolously files these claims, and is not able to substantiate this before the NCLT, then the NCLT will dismiss this application with costs. And if it's a
So,
public company, then even worse, because then you will also have not deformation, but I would think that the cost would be higher. But we've seen very few cases where, I mean, there have been cases, but it's not, been very large in number where, people have gone to sort of arm twist corporate debtors on this account.
okay, we've been talking about the role of NCLT so far as an adjudicating authority, wherein speaking of adjudication in India, dispute resolution in particular, in India the winding up an insolvency is non-arbitrable. Should it be allowed to resolve through arbitration as it should support the system to deal with the NPA problem? This is a question again by Himanshu.
Sorry, this is the resolution through arbitration of the NPA problem, or specifically NPA?
Yes, yes, you're right.
Okay. We have not seen cases where NPA is being sought to be resolved through arbitration, because NPA classification is an RBI mandated classification. It is not something that the banks can resolve separately, even if the banks wanted to, because at the end of the day they're bound by the mandate of the RBI. And more often than not, you will always have it's not just one financial creditor, it's several financial creditors. So if it's a simple factual scenario where if the corporate debtor had the money, then they would pay that money and avoid this entire NPA classification. The entire issue arises because the corporate debtor does not have sufficient funds to discharge their dues, so whether it's principal or interest, in which case there is no getting out of the NPA classification. It is not that the banks can contractually agree or enter or contract out of this RBI mandate per se, whether it's through arbitration or contractually or otherwise. And therefore you won't see a lot of cases where NPA is being sought to be resolved through arbitration.
All right. Thank you so much for that answer, Himanshu. I hope that answers your question. My question to you is that what are your views on the eligibility restrictions which have been brought forth by the amendment?
Okay, so to give everybody out there a background, the Insolvency Code, when it got notified, allowed any person to present a resolution plan. Basically, anybody could bid for the company. However, given the fact that banks were taking very deep haircuts, by haircuts I mean that a third party bidder will say that okay, 100 rupees is owed to the banks. I'm willing to pay 50 rupees. Let the bank write off the other 50 rupees as unsustainable debt. And ultimately, given the fact that bank money is public money, in very layman terms, there was an amendment which was brought forth in the insolvency code, which forbid all promoters from bidding for the company. So whether it's promoters or persons acting in concert with the promoters, which means that any person who's a related party of a promoter, or any person who has had an NPA classification, or any group company of that bidder has had an NPA classification, or any criminal conviction. So there were certain thresholds which were set for to make sure that any third party bidder who bid for the company was a person who had a relatively cleaner record, and who was not really going to bid for the company and then bring it back again to the same issues of NPA and default, etc. And therefore this amendment was brought forth by virtue of section 29A of the code, which remains the most contentious section, so to speak, because as we know, there are a lot of companies and big conglomerates for that matter, who have been who have had issues on eligibility because of this section, because it's that widely worded. But having said that, there's always structuring which can be done, in a law-abiding manner, and keeping in mind the objective of the code.
Okay. I'm going to take another question right now, and this question is from Himanshu Mene. And the question is that IBC does not have a provision for cross-border insolvency. What are your comments on the same?
So, cross-border insolvency, there is a section in the code which has also been notified now. There are two aspects to cross-border insolvency. One, that the courts can possibly, approach or write, a letter to another authority or courts of a jurisdiction, setting out that, a particular corporate debtor has gone into insolvency, and two, that the government at some point of time will enter into agreements with various jurisdictions. We have not, entered into the unilateral, cross-border insolvency agreements, and therefore, as of today, we don't have that arrangement with respect to cross-border insolvency. But we need to give the entire regime some time. It will not happen overnight, but it will definitely evolve, in line with the developed regimes.
Alright. I have a question to you, which is regarding the limited insolvency exam. What do you think, as per you, is the biggest challenge in cracking the limited insolvency exam?
Biggest challenge. So, I mean, we'd seen the portion of the of the limited insolvency examination, and that is, it's something that can be cracked, especially because it'll be sat by, people who are relatively senior. National insolvency examination is not something I'll be able to comment upon because I have not seen the portion myself, and I'm not even sure if that's now, been notified, because until very recently, at least to my mind, it had not been notified. So we can talk about the challenges, once we have some precedents to go by.
Uh, why don't you tell us something about the kind of cases that you deal with on an everyday basis, and what is the general research, or what is the general work that you need to do as somebody who's working on insolvency issues on a day-to-day basis?
Sorry, Aditya, your voice is, I think the line is breaking. You'll have to repeat that question.
Why don't you tell us a little about what are the biggest cases that you need to deal with on a day-to-day basis, and what is your day-to-day work profile look like? What are the major laws and research areas that you need to work on as an insolvency expert?
Okay, so so far as the day-to-day, work profile is concerned, it's very interesting. So anybody who's looking to do work within the insolvency and restructuring regime, can take note of that. We like when you're preparing a resolution plan, you have to look into every aspect, and it's not just limited to banking laws. So you have to look into your SEBI laws to make sure that what are the compliances that the corporate debtor is required to comply with. If the corporate debtor is a public listed company, you need to look into your competition laws, because if you are a big conglomerate, you have to make sure that you are not hit by the competition act restrictions. Similarly, you have to look into your companies act, because all the procedure has to be followed. So, for example, if you're doing a merger or if you're doing a share capital reduction, that procedure also even if not followed strictly under the Companies Act, when you're applying to the NCLT for approval, it needs to be in line with what the regime as of today is. You can't do something which is completely out of the box. So while this is a window for resolving, it still has to be done keeping the applicable law in mind, and that encompasses all your existing laws. So whether it is Companies Act or stamp duty or income tax or competition, for that matter.
Thank you so much. Could you give us a glimpse of what has been the most challenging responsibility you have been entrusted with so far as an insolvency lawyer?
So challenging, it's always the timelines that are challenging, because the turnaround has to happen like overnight in so many cases. Given the fact that this entire regime is time bound. And a lot of times, I mean, if we're representing the resolution professional, who's a client, he'll say, okay, but this needs to be done urgently because we have a creditors meeting lined up for tomorrow at 2 o'clock. So please send it to me by like 9 a.m. in the morning. So which gets very difficult to turn around because at the end of the day, you like when you're submitting a product for voting before a committee of creditors, which can essentially have like each creditor of like from a State Bank of India to an ICICI bank who are and even these COC members have very senior representatives on the committee more often than not. You have to be very thorough with what you are doing. So whether it's a note that you're preparing on the applicable law, or it's an advice, or whether it's a review of the resolution plan, where you're giving a go ahead saying that okay, this is in sync with everything under applicable law. That is something that can always get challenging, and it's again it's not something that everybody has. We don't have a lot of precedents to go by. So everybody is still learning and seeing how this is working out, especially to see how NCLTs are looking at this entire regime.
Okay. I'm going to take up one final question from Himanshu Mene, and that is, what measures would you suggest to improve the performance of the code?
Um, to improve the performance of the code is yeah, there actually, I don't know if you had the chance to read this, but there has been recently there has been an insolvency committee report which has come forth. While of course this is a very nuanced question to go into in a lot of technical detail for the audience here, but for example, if it's a public company, the code or the regulations as of today don't provide for delisting measures. So what happens in that case? And therefore, the insolvency committee report has proposed, certain amendments to be brought forth, or for certain, steps to be set out with respect to public, listed companies. Similarly, with respect to certain other issues, for example, guarantors. So to make this really simple, let's say for example, if I've given a guarantee in respect of a corporate debtor who's undergoing moratorium, and actually that bank cannot recover it from the corporate debtor because he cannot invoke the guarantee, because under moratorium you can't do anything against the corporate debtor, you can't litigate against the corporate debtor. So the bank will come after the guarantor. And what are my rights? Then can I say that no, I will not pay this amount because the corporate debtor is undergoing insolvency, or am I as a guarantor bound to pay that amount? And if I'm paying that amount, then technically I also become a creditor vis-a-vis the corporate debtor. So that is again a gray area, and that's something that the insolvency committee report has proposed to set out in more detail. So you can have a look at the insolvency committee report. It's available online again on the ibbi.gov website, and you can reach out to me or to the Lawsikho team on any other questions that you have.
All right, thank you so much for the heads up, Dhwani ma'am. It's definitely, I'm sure Himanshu Mene definitely is going to reach out to you. Uh, okay, I will take one question which is a little off track, but I think it is going to benefit the viewers who are watching us right now. This is a question by Kunal Chandriani. He wants to know that in a top tier law firm like Khaitan and Company, the assignments are very vast and provide a wide array of skill development. Does a small law firm provide even 50% of that experience?
Sorry, your voice was just mute in the middle. You'll have to repeat that.
Okay, so this is a question by Kunal Chandriani. His question is that in a top tier law firm like Khaitan and Company, the assignments are very vast and provide a wide array of skill development. Does a small law firm provide even 50% of that experience?
So, I mean, I would not want to discount small law firms because, yes, there are some small law firms who are doing good insolvency work. Honestly, it depends, on which law firm it is and, who the partners of the law firm are. Having said that, all the volume insolvency work is happening, at the bigger law firms level. Not because of anything else, but purely because of the, number of resources that you need for, like literally each insolvency matter, which is, very rigorous on the timelines. But if you are aware of any partner or any law firm who is doing insolvency work, I would suggest you to, go ahead and, I mean, apply for an internship or for a job, as the case may be, and not really go under the, like tag of a big firm, because ultimately you want to do good work. So, if you are aware of people, who are doing work within the field that you want to do, whether it's insolvency or otherwise, you must always give it a shot. You must not be too particular about a tag. It should always be work and the quality of work that takes precedence.
All right. Thank you so much for that answer. One final question is any closing notes for everybody who's watching us right now?
You'll have to repeat that.
One closing note for everybody who's watching us right now.
One closing note. So this has been, a good session. It's been a good sort of conversation. And anybody who's looking or is interested within the insolvency and restructuring regime, please go out there, read the code, read your online articles and wherever it is. So if you're, in your second, third, fourth years of law school, you can go ahead and apply for internships at, the appropriate law firms, or you can always, I mean, look at writing research papers. There's so much content, and there's so much that's happening at the NCLT level. So it's something that you must watch out for and keep updated. And if not insolvency, there's always so many other fields of law. So it's good to know what you want to do, as law students, and keep interning and keep progressively working towards that. It's important.
Thank you so much, Dhwani ma'am. It was an absolute pleasure to have you on this show. We hope that you will be, you will be coming on this show again, talking about some other issue in the near future. Thank you once again for being a part of this, and it was an absolute pleasure and very enlightening to have you on this show. For everybody who's watching us right now, don't forget to like, share, and subscribe. We'll be back tomorrow again, 8 to 9, with yet another expert talking about a different field of law. Don't forget to like, share, and subscribe. Hit the bell icon because we are going live every now and then with another expert talking about various issues of law that is definitely meant to help you. Thank you so much. This is me, Aditya, signing off at 9 o'clock in the evening. See you tomorrow again at 8. Till then, have a great day ahead, and till then, out, Lawsikho.